Good morning, everybody. I was asked by Christina to provide an overview of what our institute does in the areas that might be of interest for you and briefly present research results in these areas. I also provide names of researchers that you could contact if any of these projects that I briefly show you would be of interest within the framework of the project. So it's mostly ETUI research agenda dealing with migrant and posted workers. I have to put this up nicely. And so, as we discussed yesterday, different channels of labor mobility translate to very different regulatory regimes that stand behind it. There is the migration, so a permanent move, in which case workers are subject to laws and regulations of the host state. Posting, when the situation is, as you know, quite different, with the minima applying and social security being paid still in the country of origin, tax after 6 months paid in the host country, so a total mix of different regulations. And self-employment that is not employment, this is like a business activity, however, often taking the fictitious form of bogus self-employed workers being hired by companies, but not companies that they are not responsible for their conditions. These different regimes translates to different projects that we run at ETUI, and we understand worker protection as phrased in the title of the presentation very broadly. So in the unit that I represent, the Economic, Employment and Social Policy unit, we look mainly at employment regulations and issues related with working conditions and their abuse in a trans-border labor setting, whereas Victor and his unit deals more with the issues of occupational health and safety. So I think both would be relevant to you, Victor being a more professional in the health and safety projects, and we providing a background perhaps for the literature review and for the case studies. So we run three in my unit, the Economic, Employment and Social Policy unit. We run 3 projects that could be of relevance for POOSH and you. So my colleague Bela Galgoci, since I only remember, has been dealing with labor migration analysis of trends in terms of employment, unemployment patterns of labor migrants in the EU, especially Eastern migrants in Western countries, sectoral distribution of their employment, occupational and skill profile of labor, mobile labor, Eastern mobile labor in all EU member states. And there were 2 projects, one launched a couple of years after the enlargement, still during the good times, but dealt with analysis of numerical trends, but also policy responses at the state and trade union level. And this second project that I present here, in the time of crisis, to see really what changed in terms of all these patterns that I mentioned during the time of the downturn. And the findings from a network project that involved a number of countries, and again, checking the situation of Eastern migrants in West European countries, was that, they were very often serving as a labor market buffer. So the rates of employment were usually quite high before the crisis, because that's what kept them in the countries to which they went. But then they were more affected by the crisis than the nationals, and they were dismissed in the first place. They were also concentrated in certain sectors of employment in which they usually performed work that was below their qualification. So the main conclusion from the project was that free movement was beneficial in many ways, but then the underutilization of human potential and the underqualified jobs that the migrants take, as well as the abuse and legal loopholes that you are well aware of, constitute the biggest problem. And here the outputs were 2 edited volumes, quite interesting volumes. First, from this first phase of the project, still before the crisis, and the other one on the project that I just mentioned, during the time of crisis, the patterns, the skill mismatch, and the problems related to this, as well as our working paper summarizing the Green Book results. The 2 books were published with outside publishers, Routledge and Ashgate, whereas the working paper is our publication available on the website. If you need any specific chapters, just contact me or Bela, and yeah, that would be sent, of course. Now, I was a manager of another project that is also related to POOSH, and that dealt with the concept of social dumping, the way it is used or abused in the public discourse. We tried to basically rethink what is the essence of social dumping practices, so that to avoid naming, shaming, East-West sort of accusations that were quite present in the enlargement and post-enlargement debate. So we wanted to provide a sort of definition that captures the mechanism behind these practices and look on different practices that meet the social dumping characteristics, both in the area of migration and posting, but also in manufacturing. And these were things related to internal organization of labor, outsourcing practices, cross-border investment strategies of companies, and also national and EU-level policy measures that were conducive to then, so that made it easier for actors to perform social dumping. So in this project we conceptualized it, deriving it from sociological but also economic literature as the practice of undermining or evading existing social regulations undertaken by market actors to gain competitive advantage. And in different sectors, it was again a network project with case studies in these 3 different areas. And in different regulatory systems, of course, this type of breaching and circumvention took very different forms. So it looked differently in Denmark. There were different possibilities for it there than in Austria, for instance, with the very legalistic regulatory setup. But the project was quite interesting. The case studies enabled us to dispel a number of misconceptions as we thought about social dumping. So the undermining logic of undermining, trying to go around the rules, is not specific for EU enlargement, as it was always or very often used in policy discourse. It's not migration on posting that is the only area. So we found many examples of it in the manufacturing sector. It was not only low-wage country actors, as it is always presented, or very often involved. Very often this type of practices were pushed or at least tolerated by main contractors that profited from things being very irregular at lower levels of the chains. And it was not always a necessary cross-border phenomenon. So these practices we see also in terms of the precarization in national settings, the way in which permanent workforce is being replaced by the employers by more precarious workers that are cheaper and more easy to manipulate. We also had a specific case, a chapter in the book, and also a policy brief in the institute dealing with different social dumping practices related to posting. And there 2 colleagues, very good friends also, Sonila, Nathan Lilly and Lisa Benson, identify 3 specific patterns of social dumping. One being an outright violation of rules. If you just do things as you shouldn't and you try to conceal it, that would be the regulatory evasion. Regulatory arbitrage, that is more related to the fact that you can, given the regulatory cross-border setup, you can take different bits and pieces from different regulatory systems, which is still very legal, and you strategize between these different norms, trying to look for cost savings. And for instance, posting workers from another country where social contributions are cheaper to yet third country, it's an example of this sort of strategizing between different systems to achieve lower cost of labor. And the third type of abuse was a conformance with a specific national setup, but in ways that, again, enables this type of cost advantages. And an example that was used by the authors was from the Netherlands, where the temporary work agency scheme enables enables employers to use 3 different types of contracts. The first one, the one that you start with, is the most basic. It's a 0-hour contract, but it has to finish after a certain amount of time. If you, however, send a worker after this amount of time for a couple of months home, you can then re-employ him on, again, this very basic contract. So it's within one system, but it enables you to basically still exploit the fact that, yeah, you can offer minimum conditions. And we had also a number of publications. The volume was published with Routledge externally, but then the very interesting policy brief that I mentioned is at the Institute website, together with a number of other publications. So the introduction and conclusion of the volume is in the third one, that's the working paper, and then 2 other policy briefs out of chapters in the volume. The last from our project, it was also one in which Sonila was participating, was run by my colleague Jan Drachokopil, who is an expert in MNCs, multinational company strategies, and also he had a project on outsourcing, and part of the project also dealt with posting. So apart from just outlining the trends in outsourcing, its impact on working conditions, union organizing strategies, several participants of the project looked also at the posting. And then the findings of the studies were very similar to my social dumping project. So again, the posting construction was very often used as for service providers as a tool to circumvent host country regulations and exploit the differences, especially given that law enforcement was difficult. And yes, Sonila also wrote, with Margus Ipola, wrote a small policy brief on the basis of her study on different strategies of organizing posted workers, difficult as it is given their hypermobile character, with several strategies for unions, including a more proactive approach, coalition building with organizations among the migrant workers, but also perhaps a need for transnational forms of organizing. So it's again downloadable on the website. And there is also a book that summarizes the broader project. The last thing that I wanted to mention is a new project that I will start now with my fantastic new colleague, Zane Rasnacha, a Latvian lawyer. And we will try to look at the national case law which was related to posting. So that would be cases which were brought by workers themselves, companies and trade unions. So we still, from the pilot study that we did on Latvia, it seems that there's still very basic problems with the application of the posting regulations, including the fact that courts don't recognize that they deal with posting in the first place. So very, very basic problems emerging. And we wanted to see how in different political, economic, industrial relations settings these problems look. So are there any patterns that follow the regulatory setups in the countries, and then that translate to specific problems that emerge in the application of posting regulations. And then on the basis of this, we still see how we go about this. We want, again, this to be a network project of lawyers that will analyze the case law, and on the basis of this, we want to make this comparative analysis and also formulate some recommendations given the problems that actors encounter. And it's just about to start this spring. Very quickly about the health and safety unit. Victor presented it in much more detail, but as he said, it's not really that we run at the moment a specific project on migrant workers, but given that they are de jure to be subject to very same regulations, all these policy areas that health and safety unit deal with are indirectly applicable also to the migrant workers. So yeah, Victor presented yesterday the spheres that the Health and Safety Unit is active, ranging from EU policies to very specific questions of substances that are so health and safety issues in all its variety. And they also have, I would like to keep your eye also on their publications, the HESAMAG, and two issues that were perhaps the most relevant for you, one on the construction workers and irregularities in the construction sector, and the other on labor inspections in Europe. They also work very much with expert networks, as we do, and they also have a more active role in actively participating and representing even the ETUC in certain committees and tripartite bodies at the EU level. So they're more applied than we are. We are more researchers. These are usually people trained in engineering, people to have this double sort of portfolio of both researchers and experts that can then provide valuable inputs in the negotiations on specific regulations. And yeah, he also spoke about the project on migration that was co-managed by the Institute, and I'm sure you can get also access to this publication. What was interesting, what I found in his presentation was basically the idea of having good practices of action as well, not only the bad practices, and also really very strong emphasis on policy recommendations. So I think that would be also useful in the POOSH framework. So that's a short presentation of what we did and in what ways perhaps we could be useful for you as a source of info or publications or consultations for the project. Thank you very much.
Okay, thank you very much for giving me this opportunity to present part of my research. As the title suggests, I did some field work in the UK as part of a bigger project on transnational work and the evolution of sovereignty that focused on posted work in 4 countries, Finland, Germany, the Netherlands, and the UK. But my field work was in the UK, so I'm going to talk about that experience today. This is a brief outline. I'll just raise the questions, the theoretical background I've used for it, describe the cases, pinpoint to some of the findings in relation to health and safety, and then draw a couple of conclusions. So the questions are very basic, although my research was broader and I was interested in other aspects as well. Today, the question I raised is, what are the occupational safety and health issues faced in a multinational construction workplace where part of the workforce is posted? And how have these issues been dealt with in the UK? Now, a little bit about transnational multi-employer workplaces. As the term suggests, we have multiple employers, both native and foreign, all operating in the same workspace. And there is usually, in construction, there is a long subcontracting chain. There are different terms and conditions sometimes between workers, and there's also a lot of shifting between different forms of employment, even for the same person. Like they may be hired firstly directly and then through agency or one of the subcontractors and the like, and then go back to more direct forms within the same workplace during the time of a particular project. Then the literature has also identified the need for mechanisms to audit, report, and facilitate communication as well as monitor what's happening between these subcontractors and what happens to the people who actually do the job, like the workers on site. And this need becomes important because of the long chain. It's often unclear who is responsible for what and where people can actually address their individual grievances. Now, in terms of occupational safety and health, I've used the framework proposed by Sargent and Tucker. They call it the layers of vulnerability, and they focused on the migrant workforce. So according to them, that there are 3 different layers. Each of them has its own components. The first one is the migration factors. They explain that the status of the migrant is very important to the level of vulnerability he or she is exposed to. And I think it was already mentioned yesterday that, for example, irregular migrants who have no paperwork or who are employed informally are more vulnerable because they are basically invisible than other kinds of workers in the work site. But we notice that others as well have different kinds of face different kinds of risks in a workplace, including posted workers. And then the second criteria is the conditions of recruitment. So are we talking here about temporary workers, agency workers? Are we talking about long-term migrants who have a permanent contract with a particular host country company, or is it a subcontractor that brought them in for a particular period of time? All of these are impacting the vulnerability level of migrant workers. The second set of factors is the characteristics of the migrant workers themselves. Now, the first one is about the socioeconomic conditions in the home country. These, the authors explain, has to do with how poor and prone to unemployment the sending country is, because usually that affects the level of agency the workers will display in the host country. So if, for example, they don't want to go back because there are no opportunities there and they feel that they won't find another job, then they are less open to reporting things that they find wrong or that might expose them to risks to health and safety. So they will comply to poor working conditions, basically, regardless. The second has to do with the education and skills level. So have they been trained in the particular profession that they are doing as migrant workers or as posted workers? And do they have the skills to recognize that this is dangerous, for example? And the third sub-level is the language skills. So do they speak the language of the host country? Are they able to read the signs and the instructions? Are they able to communicate with health and safety inspectors to report their grievances and these kind of issues? Is there any mechanism of facilitation in terms of interpretations if they don't? And the third set of factors is consider the receiving country conditions as well. So first is the characteristics of employment and sector, how dangerous the job is, how prone to risks and health and safety issues they are exposed to. And of course, some sectors are more dangerous than others. And as the literature and many of our studies indicate, usually migrant workers are located in these risk-prone sectors or jobs. The second factor in this third category is access to collective representation. It is believed that collective representation covers not only political and social and economic aspects, but also health and safety, because then, you know, you already have a channel of communication that will defend your rights if they are breached. Third is access to the to the regulatory protection. So, are you entitled to make claims in the host country, or is it only for indigenous workers? And different countries apparently have different regimes and provide different levels of access for different workers, depending on their status. And the fourth one is particular problems related to social exclusion and isolation. So obviously the level of racism and discrimination, which might intimidate certain workers and prevent them from stepping up and speaking if there is some problems in the workplace related to health and safety, or if they will be ignored or not by the local representatives or the trade unions on site. So, of course, then we have to see what's happening in the ground for all of these factors. Now, briefly about health and safety in the UK, there is a legislation obviously in place that covers different aspects of health and safety, and then it's a broader one and the more specific according to the industry. And what is special, in quotation marks, but different anyways, in the British case is that there isn't one labour inspectorate that covers all aspects of employment. You have different authorities, different agencies covering different aspects. So the health and safety executive monitors and follows the issues of health and safety in the workplace, and they share this responsibility with the so-called local authorities, which are actually independently elected bodies and individuals that monitor the observation of health and safety regulation at the local level and in the workplace level. And even the trade unions are involved in this local authorities part of the job. And then the Employment Agency Standards Inspectorate covers only what happens to workers hired through employment agencies. The Gangmasters Licensing Authority, as it was already mentioned yesterday, looks for exploitation of workers more broadly, but migrant workers in particular, and try to report and fine employers that do that. Whereas the last one, Her Majesty's Revenue and Customs Authority, is the authority that is responsible for observing the minimum wage is granted to all workers within the UK. So each of them has different duties, and some of them collaborate with each other to guarantee health and safety. Now, about my own particular case study. 2 words about engineering construction in the UK. It's a local industry because you build locally, but it has an internationalized labor market. And most workplaces, especially Project 1 construction sites, which are like the largest out there, are multi-employer and transnational workplaces. The industry is project-based and transient, so people are hired just for the duration of the project and then rehired later by different employers for a new project. The workforce is quite contingent, and in the case of the UK, it has the highest number of posted workers. My research was conducted in 2014 for 6 months, and then I did some follow-ups in 2015. I researched 2 work sites, one power station, combined cycle and gas turbine station in Carrington, and the coal-fired power station in Ferrybridge. Did a number of interviews with posted workers, shop stewards, managers, and this is a qualitative analysis, so the findings are based on that. Now, these power stations are in remote areas. In the peak times, there were 27 companies operating in the same site. And if you think in terms of, I forgot to put the number of workers, it was between 400 to 500. So 27 companies for 500 workers. You can imagine how, broken down to different levels the work process was. 20% of the workforce was posted, and the others were local and agency workers. There is an agreement that the trade unions have made with the employers that they will guarantee that only 20% will be brought from outside the UK, and the rest should be local workforce. And this happened after the Lindsay oil refinery dispute in 2009. In one case, in Carrington, all posted workers were Spanish, with a few exceptions, like from Ireland, and the rest in Ferrybridge, they were from different countries. It was actually called the United Nations of construction sites, that place, because it had people from everywhere, from Belgium, Germany, up to Slovenia, and actually, I didn't meet them, but it was rumored that there were people from Bosnia as well, and apparently they could come through posting of EU member states. Both cases, and I consider this a good example of how posting is done in the UK, or relatively good. Both cases were operating under the National Agreement for Engineering Construction Industry. So there were union present on site. And of course, there is a big difference between sites that are unionized and the ones that aren't. And you'll see why. But anyways, regardless of that, I identified several irregularities. The first thing is that it was normal and typical to have long working hours, 5 days of 10 or more hours, Saturdays, and often Sundays because there was a deadline to meet. So people normally worked 60 or more hours per week. And then, although the NIKI, which is the abbreviation for the collective agreement, guarantees equal pay for all workers, I found out that there was a lot of, evasion, conformance that Magdalena already mentioned, with people being paid less, people not being paid for 50 days, people being paid only the first ticket, but not the regular frequency guaranteed by the directive, double books, and not in the 2 cases I studied, but earlier examples in the UK, the unions reported poor accommodation and living conditions. Now, the occupational safety and health implications. So there was a lot of pressure for workers to work faster and do more within the time frame, and also to work longer hours, as I already mentioned. And this, of course, meant that they were tired and they were often unwilling to talk to me because, they returned home late and they didn't want to, chat. They just wanted to go to sleep and restart over the next day. So that was actually one of the difficulties of trying to find the time to meet them and talk with them, because usually these conversations go longer than half an hour. So exhaustion was one element. The other thing is the language barrier. I'll talk a little bit more about that in a few minutes. But the safety in the workplace. This was the main issue that was raised by both posted workers and trade unions, the discrepancy of skills. So some people were hired for a particular skill which they were not trained to do, and that, of course, exposed them to risks of health and safety. The British trade unions, I'm taking this with a bit of salt, but they were saying that in the UK the training is very specific. If you're a welder, you're a welder. If you're a pipe fitter, you're a pipe fitter. If you're a rearer, you're a rearer. And you shouldn't do the other things. But for workers coming from Eastern and Southern Europe, it was common to do both, or switch from one task to the other if necessary. And they, according to the British, this exposed them to dangers in the workplace, and it shouldn't be done. And sometimes they were forced to, because foremen told them do it. But the thing is that if they were caught doing it, and they might be fired, then the foreman would just say, like, he did it on his own, I didn't tell him to do that. So, and the workers were aware of that and kind of felt like sometimes they didn't have a choice, and only very few of them actually reported it. And like these 2 quotes sort of illustrate what I just said, but I will skip because I'm running out of time. Now, how did they deal in the UK with issues of health and safety? First of all, there is a National Joint Council Guide to Health and Safety and Welfare, which is cross-referenced and the collective agreement. So it's very important that these things are interconnected and refer back and forth to each other. Apart from the national level, there was a project health and safety plan. So each project have their own plan for health and safety. To make that available to the workforce, these health and safety instructions were introduced during the induction process, which is what you do right before you start a new job. So you're told about all the health and safety issues, other things as well in the induction process, but for this presentation, this is what is important. And in Carrington, where all the posted workers were Spanish, it was done in their native language. Whereas in Ferrybridge, where there were a lot of people from different countries, it was done through interpreters and translation. Now, apart from the induction process, as there was monitoring on site from health and safety reps, if someone was found doing things inappropriately, then the toolbox talk happened. That meant that either the workers who were doing things in a risky way and their subcontractor would be invited and explained once again the health and safety regulations of the site. In Carrington, again, because posted workers were only Spanish, then all the posters and the instructions in the cafeteria and everywhere were bilingual. So they were in Spanish and they were in English, exposed for everyone to see and refer to. But in the other case, there were leaflets provided in different languages, and not necessarily all the languages people spoke on site. There were safety representatives on both sides, and these people are appointed by the unions, but of course they are also workers. So basically the agreement between the unions and the employers is that these people should cover all health and safety situations on site. They should regularly monitor the site that nothing is happening that is wrong. So it's not only when someone goes to them for an issue, but they also do proactive monitoring of the site and observe what's happening. And that time is still paid by the employer regularly. So it's not like you either have to do your job as a construction worker or be a safety rep at the same time. There is a 4-stage grievance procedure that starts at the workplace, where you try to resolve a dispute within the workplace before moving up the ladder to the national level and the labor court. And there were, in both sides, monthly incident reports, which were submitted to an external audit and to the Project Joint Council, which is a council where representatives of workers, employers, and community get together every month and discuss the progress of the work in the construction site. Now, the importance of unions in the British construction sites were actually reported by both. Of course, the unions were more vocal about it, saying that if you have a unionized site, then it's safer, and because then we provide the safety reps, and we have regular reporting mechanisms in place, and that makes it easier to monitor and prevent things before more severe accidents happen. And this is a picture of one of the sites in which they, as you can see, it's poor quality, my phone is crap, but it tells the time, the weather, the total project hours to date, and the number of workers on site. But the other thing that is reported already is lost time injury. This LTI is like, so 191 days without an injury that had caused the work process to be stopped. And that was a matter of pride for them as well, actually, to say that we have had very few, actually almost no injuries on site. Now, the language issues. The guide already predicts the fact that some workers won't speak the native language of the local language, so they stipulate that there should be assistance to make that happen, so that they understand what the health and safety issues are and how to protect themselves. The leaflets and professional or peer translation. Peer translations, it was quite common because it's expensive to hire an interpreter to have them browse around a site, especially if it's a power station. But then they used one or two of the workers who spoke some English or more, and then the communication was done through them, and you can imagine what problems can arise from that as well. Now, let me draw a few conclusions. What I found in the case of the UK, although there were quite positive examples, is that still posted workers are quite vulnerable to occupational safety and health risks. And they stem usually from their status as temporary and mobile workers, their professional skills, their knowledge of the local OSH regulation, their language skills, the workplace practices, and their access to representation if something happened. So in the end, I would conclude that while the host country regulation might provide protection for posted workers, the issue becomes about access to such protection and enforcement of the regulation itself. Thank you.
Good morning, and thank you for inviting me. Well, the construction sector is the most important sector resorting to the posting of workers. In 2014, the construction industry held a 43% share of A1 portable documents. Workers are employed in all branches related to this industry, such as construction, repair, upkeep, alteration, demolition of buildings, excavation, earth moving, and so on. And the posting of workers is usually adopted in the subcontracting chain, particularly through the use of temporary work agencies. Cases of in-company postings are very rare, and they involve a very limited number of high-skilled workers. Even if there are no statistics concerning the size and the characteristics of the companies involved, field research indicates that posted workers are employed both in private and public building sites. Large multinational companies are more present among the firms that receive posted workers, while sending companies are usually small and medium enterprises which are providing services in the subcontracting chain. The work organization based on subcontracting allows to large multinational companies to exploit the advantages in terms of increased allocative efficiencies and of filling labor and skill gaps. And furthermore, large firms can often exert high competitive pressure on small firms by virtue of using posted workers with lower wage levels and lower social security contribution obligations. But I will talk about this issue later. Concerning the countries involved, workers providing services in the construction industry are posted mainly from the Czech Republic, Estonia, Croatia, Lithuania, Hungary, Poland, Portugal, and Slovenia. The main sending countries are Poland, with 124,000 posted workers employed in the construction sector, Slovenia with 52,000 workers, and Portugal with 43,000 workers. From a receiving perspective, more than 50% of workers posted to Belgium, Latvia, Luxembourg, Austria, Slovenia, Finland, Sweden, and Liechtenstein are employed in the construction sector. The main receiving countries are Germany, with 131,000 posted workers employed in construction, France with 54,000, and Belgium with 53,000. If we consider the composition of these two groups of countries, we can note that receiving countries are mainly old member states, while sending countries are mainly new member states that joined the European Union after 2004. The different composition of sending and receiving countries is closely related to the international division of labor arising in the European Union during the last 30 years. This international division of labor, which affects also long-term labor migration, is derived from the neoliberal globalization processes and from the process of liberalization of the European labor market. The deep stratification of labor market originated from these processes as practically turned the Eastern European countries into into providers of low-cost labor force to be employed both by transnational companies which relocate in Eastern Europe and companies located in Northern and Western Europe through the employment of immigrant workers or posted workers. The existing studies on working conditions of posted workers employed in the construction sector confirm the existence of a deep stratification of occupational safety and health conditions, which can derive both from a legal use of posting and from infringements of the existing regulations at the European and national level. Concerning the legal use of posting, many studies highlight that employers of the construction industry are using the posting of workers because of the cost advantages of posting from countries with low social security systems to countries with better social security systems. In some cases, the cost differentials between different social security rates can mount up to 25 or 30%. And this has led to a number of practices to get the most benefit from social security differentials. For example, it has been reported the case of a Portuguese temporary agency firm that posted Polish workers to work in the Netherlands, adopting the Portuguese employment contract because this kind of contract allows to save up to 19% compared to the Dutch contracts and up to 13% compared to the Polish contracts. Moreover, the posting of workers allows cost advantages through the application of the minimum standard rule. The payment of minimum wages instead of prevailing wages in the receiving countries allows to avoid the application of collective agreements negotiated at local or company level, which are generally applied in the case of workers employed by national companies. There are no statistics concerning the real wages of posted workers. However, a number of fieldwork studies have detected that posted workers receive lower wages than local workers, particularly if they are employed in labor-intensive sectors such as construction, transport, tourism, or care work. Focusing on the construction industry, in the Netherlands, trade unionists have detected cases in which posted workers are earning less than the universal minimum wage. The Danish employers' organizations also provide evidence that posted workers in the construction sector, on average, earn 10 to 15% less than local workers. And in the German case, the average hourly gross salary in the building sector is 32% higher than the minimum wage for skilled workers and 56% higher than the minimum wage of unskilled workers. So in some cases, also using a legal way of recruitment, employers can reduce in a deep manner the labor costs. Concerning the infringements of the existing regulations at European and national level, we can observe that labor costs can be decreased also through the worsening of occupational safety and health conditions. So we have to consider the worsening of working conditions as a pillar of the labor market stratification, both at national and transnational level. Posted workers in the construction sector are employed mostly in labor-intensive and low-skilled work. And as a consequence, they have to work longer hours for lower wages, particularly if we compare their situation to the receiving country average. Their health and safety are more likely to be at risk, and they do not get any vocational training usually. Additionally, despite being usually high-skilled, posted workers have often to sign low-skilled job contracts, which allows employers to cut their salaries. In many cases, outsourcing in construction entails a multi-level subcontracting system involving posted workers from a range of different countries, which makes communication among these workers rather difficult. And furthermore, posted workers appear to have little awareness of their rights, mostly because of the lack of union representation and their social isolation in receiving countries. Disrespect of working conditions is typical and is affecting both large and small construction sites, as well public and private sectors. According to a comparative research by Jan Kremers, disregard of labor standards specifically involves wages, working hours, health and safety conditions, housing and transport. Concerning wages, they do not correspond with the working hours or the skill level, and overtime, and in many cases, overtime is not paid. Workers often receive a regular pay slip, but are paid only a part of their salaries because of unlawful deduction for administrative costs and systematic refunding to employers when workers return to their country of origin. And then usually employers choose the cheapest collective agreements to prepare the contracts. Concerning working hours, posted workers are systematically employed for longer working times than allowed in collective agreement of receiving countries. In many cases, they receive salaries that respect the minimum wage levels, and they are paid for 40 hours a week, but they actually work more hours than they are paid for. And another issue that has been reported is the non-respect of daily and weekly rest periods. Concerning health and safety, posted workers are more at risk of accidents in the workplace because training is usually not provided, and health and safety rules are often provided only in the receiving country language. In many cases, they have not the necessary protective equipment, and we have also to consider that the fatigue related to long working hours and heavy workloads. Concerning housing and transport, many studies have highlighted that deductions for housing and food in breach of the posting rules are very common. In many cases, posted workers live in very poor housing conditions, and they are socially isolated because they are separated from the local population and their colleagues. And finally, several studies detected also a number of practices for further decreasing labor costs. For instance, subcontractors often do not pay social contributions in sending countries, or resort to letterbox companies, or resort to bogus self-employment system. And thus, employers illegally reduce labor costs, playing on the gaps among member states' social contribution systems. So, I would like to conclude resuming some of the issues that emerged during the transnational joint visit, which was held yesterday as a part of the POOSH project. Posting of workers must be analyzed considering the transformations of the labor market and work organization, such as in the case of construction industry, such as the intensification of the use of subcontracting. And then we have also to consider that the worsening of working conditions and the deepening of labor market stratification are due to a combination of various phenomena, such as the diffusion of social dumping related to the posting of workers, but also the diffusion of undeclared work, of temporary contracts, of depending, self-employment, and so on. So these phenomena are contributing to a general precarization process, are worsening the working conditions both at national and European level. We also need to take into account the fact that these working conditions will not remain confined only to posted workers or to the construction sector. These working conditions will affect the working conditions of more guaranteed labor force, such as local workers or workers employed in more guaranteed sectors, such as the public one. And to stop this race to the bottom, we need an overall improvement of working conditions both at national and transnational level. On the one hand, in order to achieve this result, it is important to develop a broader and a deeper cooperation between labor inspectorates and between sending and receiving countries' trade unions. And Mercedes Landolfi will talk later about these topics. This on the one hand, but on the other hand, it is also important to promote a real solidarity between workers at international level and a common struggle for better working conditions. And this is probably the most difficult issues that we have to face and deal with.
All your presentations are very interesting for me, but I'm very interested in, or better, I have one question to all of you. Is this, all these researches, are the researchers ordered by a known client, or in another word, who use your data and results of your research?
Oh, isn't that the eternal question? Well, my project was funded by this European Research Council. So at the EU level, there is an interest to find out what's happening, basically, and the data are then made available through publications and they are open to public. I mean, of course, they go through academic journals mostly, but forums like this where we talk to practitioners. My work was with trade unions mostly, so I try to, you know, stay in touch with them and exchange the findings. And the idea behind this is to do the research and reflect upon what's happening in the field, so then policymakers can, you know, introduce. Of course, we cannot impose our suggestions and the recommendations that come out of the research, but we can still, you know, start the public debate. And yeah, sometimes it might be small groups of academics who speak the same language, but it's, I don't know. I think it's a very much more complicated question about, you know, why do we do research and why do we need it for? So in our case, we try to bridge that with policy making and with the actors who actually make decisions. And the POOSH project is also part of that larger schema in which we try to, you know, avoid social dumping through posting, and so that we can guarantee people's working and social rights.
Now, in the case of the social dumping project that I could relate most closely to, it was not ordered by anybody, but we tried to really reach very different audiences. So, I mean, I'm academic, so it's always, I'm more tempted to, you know, publish a book, and but we also, I was approached by a Polish employer organization that posts workers who wanted to know what some of them do, you know, on the bad side of the story. I was quite surprised, but I had quite long-standing relations with them and exchanging with the employers. I also took part in their congress and we discussed it. I was approached by Polish ministry. I worked with European Transport Federation, the unions, on specific patterns of abuse that we tried to really also feed into their policies. So I also had a presentation at the European Commission. This take on social dumping was taken by the European Social and Economic Committee. So we try then to, and now it's like, you know, everybody wants to sell their stuff, in not only the products, but the products of something, yeah, intellectual or research. And we, as ETUI, we have this specific mission to not to be just, you know, in the academic journals, but really to try to reach audiences and ultimately, hopefully, we hope to influence the stances and policies to some extent of actors. But it's not ordered by anybody, and it's not that conclusions are guided by somebody. So I hope, and I don't think this was the case in this project and in the project of my friends. The health and safety unit will be more applied, so they will really participate in specific committees on asbestos or anything like this. But yeah, in our case, it is more the policy makers and trying to reach them and different actors and interest groups.
Mm-hmm. Yes, well, I just presented a part of the literature review that I carried out for my PhD course. And, well, my work has been funded through a fellowship at Ca' Foscari University of Venice, but I choose to study these issues autonomously. And then, yes, for the next 2 years, I will work in the POOSH project, and yes, my work will be funded by the European Commission, but at the end, I hope that this work and consortium work will be helpful for all those labor inspectors, trade unionists, labor activists that are really interested in combating the worsening of working conditions that are resulting for a number of processes that include also the international division of labor between Eastern European countries and Western European countries.
Thank you for all of your presentations, they were very interesting. I was wondering, in Ms. Sonila's presentation, there was a mention of a grievance mechanism within the company as the first level of a grievance mechanism. I was wondering if you have any recommendations of research which actually look into company self-regulations or self-imposed accountability and responsibility under the business and human rights framework, and whether this has been effective at all. Is there any results or initiative in this field? Thank you.
Like in these two cases that I studied, the thing is, okay, because probably I need to explain, like in the UK, the collective agreement is agreement between trade unions and the employer, so the state is not involved. It's not a tripartite system. And although you have a collective agreement in place, it doesn't automatically apply to every workplace. So basically, every construction site that starts, the unions have to go and negotiate with the main contractor, usually via the client, who is usually a public service provider, like, you know, power, energy in the UK, and then persuade them to agree to apply collective agreement stipulations in the workplace, and only then that becomes the rule. But apart from this collective agreement, which is like midterm, it lasts for 3 years, and they renegotiate with the employers every 3 years to adopt to the new changes in society and in workplace. They also have, once that is guaranteed, then they have a site-level agreement, which then regulates the day-to-day. Now, the grievance procedure is already in the collective agreement, and, but then they sort of decide how they are going to do it in practice. How often are they going to meet? Who is going to represent whom? Like the people or the actors, and then the people can change based on the availability. And then who is going to be the external audit? How are they going to conduct the work? So all of these are actually decided before the work process starts in a site. And these are available publicly. If you go to the National Joint Council for Construction in the UK, you just browse it in Google, and they have all the documents public, uploaded the agreement, the site agreement, and all the monthly or yearly reports that come out of it. And so for these two cases, I can say where you can get them and see what happens in practice. But I'm suspecting that in different countries, they have different policies, and it depends how open they are to the public and how transparent and how much they want to reveal. But if they are operating under regulation, even the ones that actually do not apply them formally should have some sort of a document that regulates the whole process, including grievance procedures, because grievance procedure is part of the bigger agreement that they make. I don't know if I answered your question.
Maybe I have a small question for Magdalena. You were talking in your presentation about transdisciplinary teams within your projects. I wonder what are the benefits or obstacles, but especially related to post-it workers, not in generally, but maybe related to this topic. Maybe you comment on this.
No, so in the volume that we had in the original social dumping project, we had researchers from very different fields, and then this also, what I left to them is basically their way of work. So we had a study of a lawyer that was very legalistic once you read it. There was something that was much more sort of sociological, almost anthropological. We had economists that tried to put some numbers into the social dumping topic, very difficult, and with the caveat about the results. But actually, I think it is in a way beneficial to show that you can approach these issues from very different perspectives and grasp different dimensions of the problem. And the new project that we launch, I think that will be really important and interesting to put the lawyer, the Zane, and the network based actually on lawyers with their expertise in analysis of case law, which I could never do as a political economist. But then having me as a person who interprets and gathers these results and seeing patterns that they as lawyers would not, in their comparative methods, legal comparative methods, they wouldn't get. So I think you can really very much profit from very different specializations of people within project, because that synergy gives something and value added. And
of course, also in relation to Miro's question, I think one of the aims of research in this field is also to bridge different perspectives, and
I think it's good to profit from it and to really rework the material so that you get these different perspectives in the picture. And,
thank you. Some final comments, remarks? If not, we have a coffee there, I see, in the corner, so we can continue with the coffee. Thank you.